Okay, back to judicial review. All right. Go to this link and you will see that Congress has gotten into the habit in recent years of striking down a bunch of laws passed by Congress. The Supreme Court has become much more activist in exercising its power of judicial review in terms of striking down acts of Congress or actions of the president. All right? And what's the problem with the Supreme Court striking down a law passed by Congress or a state law? You are stuck. The democratic process is stuck. It has no way to overturn that case except one of two ways. One of two ways is, well, number one, wait around for justices to die, to have this giant political fight, over who gets nominated so that a subsequent court can overturn a case. I really didn't teach these, but there were two cases that involved sodomy, which is two men having sex. There was a 1986 case called Bowers versus Hardwick, 5-4 vote, which said laws that could make it criminal to have for two men to have sex were okay, were constitutional. I was in law school when this came out. Everybody was talking about it because gay rights advocates were thinking, well, we're going to use this right to privacy, yes, from Griswold, which said, hey, you have the right to have sex in your bedroom if you are a married couple and you're adults and nobody's getting hurt, right? That's one way to interpret it. And then Roe that says, you know what, you have the right to control your own procreation and intimacy, reproductive rights. And then Loving versus Virginia, you have the right to get married to who you want to, and they thought they were going to win. They didn't win. That exact same issue, a criminal prosecution of homosexuals for having sex, came up again in 2003 under Texas versus Lawrence, and the Supreme Court reversed Bowers versus Hardwick and said that laws that make a crime for two consenting adults to do something in a bedroom violate a fundamental right of privacy under the Due Process Clause, right? And those zones of privacy set forth in Griswold, right? All right. So that's one way to overturn a Supreme Court case. The other way is to amend the Constitution. Amend the Constitution. I want you to have an example of these. And I forgot one here. What's the big one? What's the easier one to remember? I just remember this. What's the big one that we know by heart? Plessy and Brown. Have one of these in your pocket to use as an example, all right? This one you already know. I should have had that one in my, on this PowerPoint. All right, what's the other way? Well, amend the Constitution. The easy one is Dred Scott. Remember the first part of the 14th Amendment says, go back and read it. The first sentence in the 14th Amendment says, if you're born in the U.S., you are a citizen of the U.S. That language was put in directly to overturn Dred Scott that said if you are a black man, if you are a black slave or a black man, you are not a citizen of the United States. The other one less known is the 16th Amendment. There was a case in 1896 that said the federal government was violating the Constitution by having an income tax in the 16th Amendment, which was in the early 1900s. Go and check. It said the federal government can tax incomes, right? Okay. So this is not so controversial. This is not so controversial. The Supreme Court using the power to strike down laws. But what happened that resulted in a huge expansion of federal power? And that was the Supreme Court, which court? The Warren Court in the 1960s started using the 14th, what? Due Process Clause and the Equal Protection Clause. This one through the process of incorporation to greatly expand federal judicial power. It was federal power, but it was federal judicial power. A massive expansion of federal judicial power through interpreting the 14th Amendment to start protecting rights in the Bill of Rights, right? Okay. Preemption. I don't know. I don't think they'll test you on this. I don't know, they might. They might. Look, so what happens if the state passes a law A and Congress passes a law B, and those laws directly conflict? Well, the Supremacy Clause says what? The state law fails. The federal law wins. That is preemption. If they both deal with the exact same subject and they conflict, then federal law supersedes state law, all right? What's an example of that? Gibbons versus Ogden, right? Remember in Gibbons versus Ogden, there was a federal boat licensing law and a New York licensing law. And one of them let the New Jersey guy land in New York and the other one didn't. And the Supreme Court struck down the New York law, right? That was preemption, all right? Preempting the field. God, I was just thinking of another one of our cases that was like this. You know what? In a way, McCulloch versus Maryland is that. Because, you know, Congress did not have... Remember, Maryland imposed a tax on the federal bank. There was no law by Congress that said states can't tax the federal bank. There was no exact conflict. But what did McCulloch say? McCulloch said the power to tax is the power to destroy, which means we set up this scheme, Congress did, for this federal bank. And even though there is no law in that scheme, that plan to set up a federal bank, even though there's no law that says you can't tax us, well, you taxing us would mess with that plan. So even though there's no direct conflict, there still is preemption. It's called preempting the field, all right? So, look, this is a fairly recent case. It was from 2012. Arizona passed a bunch of laws that were targeting illegal immigrants. You had to, it was illegal for you to rent to them. Cops could pull over people because they look like Mexicans and ask them their identity, stuff like that, okay? The Supreme Court struck down most or all of that law on the basis of preemption. The Congress had created a law on illegal immigration. Congress had passed a comprehensive law that created a plan for how to deal with immigration. And states can't come in and start messing with that plan by passing laws, even if they don't directly conflict with a provision of the federal law. Make sense? So, Arizona state penalties for illegal immigrants. Take this part out. Held preempted by federal law that occupied the field. Okay, state sanctions against unauthorized aliens seeking employment or working held preempted by a comprehensive system of federal employer sanctions. So the federal government had sanctions in their law, right, for undocumented immigrants working. Arizona tried to add additional sanctions. The Supreme Court said no. Congress has a plan for that. You can't mess with the plan. State authority for arrests of individuals believed to be deportable on criminal grounds held preempted by upsetting the careful policy balance struck by Congress. So Congress had this debate about what to put in and what not to put in, and Congress decided what to put in. And states can't come in and put in more stuff that presumably Congress decided not to put in. You got it? State policy of checking immigration status of individuals stopped by police during ordinary course of law enforcement act, not preempted, okay, because federal law contemplated and facilitated status checks. So, the Supreme Court said, well, if you look at Congress's law, there are provisions in there that make it sound like states are allowed to check status of people. So that is not preempted, all right? Okay, this is big. This is big. And this ties in what we have covered. And this is, look, this is where you will shine on a concept application case, all right? Okay. This idea of the Supreme Court having a bunch of power. Hamilton said, oh, well, don't worry, they don't have that much power. As it has turned out, they have exercised power in a huge way. In a huge way. Well, you know what? How do they do that? How do they exercise power in such a huge way? Well, people that are against the Supreme Court exercising such power accuse it of what? So this is an argument by people. Argument by what kind of people? Argument by states' rights people, right? States' rights people saying, you guys are invading state prerogatives by stepping on state toes. Or people that are states' rights, or people that advocate for, advocate for what? For a strong Congress, right? The people that say, look, that are people maybe advocates of democracy and saying, you know what, you shouldn't be striking down laws by Congress or actions by the president. Go back and read New York Times versus the United States, the Pentagon Papers case. They were arguing about, gee, should we even step into talking about this? Who is the expert on national security? Should we defer to the president on national security and stay out of it because, gee, we're just the court? Or should we step in? People that say, hey, look, you should have given deference to the president who wanted that injunction to stop the publication of the Pentagon Papers, because you should be deferring and not being so judicially activist, right? Okay, judicial activism. Think of Gideon versus Wainwright. What are your arguments? What are your arguments? You're going to say, well, look, you know what? The Constitution is an evolving document. We are an evolving society. This is our function. This is our function. Nothing says that we have to look at the Constitution like some dry 250-year-old piece of paper. We recognize that the meaning of the Constitution is dynamic and it changes over time. This is our job. The framers could not have envisioned modern issues like campaign finance, the internet, wiretapping. Heaven forbid, when they wrote the Constitution, they didn't know about the germ theory of disease. They didn't know about bacteria, right? Okay. People will say, oh, these original intent guys, they are just cover That is just an argument that is cover for protecting conservative positions. What is a conservative position? Preserving the status quo. Who wants to do that? Old, white, rich guys who all the rules benefit right now, and they don't want the rules to be changed, right? It's just cover for that. By the way, this is why the Warren Court is famous, because they were a judicially activist court. Now, what has been going on? What happened with Gorsuch? And what happened with Kavanaugh? I'm going to come back to this slide. Go 2 slides to this. This is Gorsuch. This is the guy. Now, Scalia was an original intent guy. So Trump didn't rock the boat so much by replacing an original intent guy with another original intent guy. But listen to what Gorsuch says. And when you're reading this, think about what the court did in Gideon versus Wainwright. Man, it is like Mars versus Venus, right? Here's Gorsuch. Gorsuch is a proponent of originalism, original intent. You can use either word. The idea that the Constitution should be interpreted as perceived at the time of the enactment. What does the Constitution say? Go back to 1787, or for the 14th Amendment, to right after the Civil War, and see what they were thinking. Interesting, original intent for the amendments is original intent at the time the amendment was proposed in Congress and ratified, not the time of the original Constitution. Tricky, right? Okay. Here's what he said in his speech. He said, what should judges do? What is my job as a judge? My job as a judge is to apply the law as it is, focusing backward, not forward, and looking to the text, the structure, and history. All right, text, structure, and history. Those are great words, right? Text, where am I? Text, that's the wording of it, right? The structure, that's also kind of the wording. And the history, well, that means go outside the document to see what people were thinking and writing, right, at the time of events in question. Okay, and you would ask, what would a reasonable reader at the time of the events in question, at the time of the writing of the Constitution or the amendments, what would they have understood the law to be? Not decide the case based upon their own moral convictions. Remember the dissent in Griswold. Remember the dissent in Roe. They're like, hey, I think this is a bad law too. We shouldn't be doing this. All right? Not based upon their own moral convictions or the policy consequences they believe might serve society best. That's not our role. Why? We are not elected. And we are not accountable, because once we get there, we are there forever. All right. Now, I'm going to stop for a second. When I love this, I see this language, and I immediately think of what case? What 2 cases? I immediately think of D.C. versus Heller, and I immediately think of one of our primary cases, McDonald v. Chicago, when using some, I don't know, fairly strained arguments along these lines, the Supreme Court radically departed from previous precedents on gun rights. They radically departed from previous precedents on gun rights to strike down Washington, D.C.'s no gun law. And then they incorporated that and made it applicable to Chicago and thus to every state in the country. So, being a judicial activist doesn't automatically mean you are a liberal. Conservatives can do this too, right? Conservatives can do this too. All right, let's read on. What did he say about this? Okay, so he said, American liberals have become addicted to the courtroom, relying on judges rather than elected leaders and the ballot box as the primary means of affecting their social agenda. Who is he talking about? Is he talking about gay people? Is he talking about pro-choice people? Gorsuch wrote that in doing so, American liberals are circumventing the democratic process on issues like gay marriage and assisted suicide. All right? I don't know why he's talking about that. Okay. American liberals' addiction to using the courts for social debate, for social policy, is bad for the nation and bad for the judiciary. Back to the slide. Okay. So what is this? Original intent. Gorsuch uses the word originalism. Originalism. Either one will work. All right. This is what Black said in his dissent. This is what the dissenters said in Roe versus Wade. They're like, come on, you're just doing this. You're just doing social engineering. You're making social policy based upon what you think is important. Boy, I tell you what, look, Roe, aside from how you feel on abortion, is there an argument to be made that the court completely did this when 46 states said abortion law was illegal? All right, okay? All right, you shouldn't be interpreting the Constitution on based on what is right or what is civilized or contemporary needs. Decisions like that should be made by who? Should be made by legislatures, elected people. Courts should not make public policy. Go back to Hamilton. Hamilton said courts are not going to be making public policy by striking down laws passed by state legislatures and Congress. They're going to be performing this mechanical, innocent function where political parties and ideology have no role. I don't know. Was Hamilton wrong? Dead wrong? All right. Everybody got it? Okay. Judicial activism hasn't always been synonymous with liberalism. The court that struck down many New Deal laws was conservative. The court, by a 5-4 vote, that struck down the law in D.C. for D.C. versus Heller and then incorporated it, the gun control law, was also a conservative court. All right. Okay, so here's what I want you to do. I want you to go back to the 15 cases. Just flip through them, all right? Go flip through them and ask yourself for each one. What was the clause at issue? What was the clause at issue? Is it being interpreted? How is it being interpreted? For example, in Engel, the majority said the phrase "Congress shall not establish a official religion" goes beyond establishing an official religion to the government being tied up or unified with religion. Period, right? And the dissent said, no, you're going too far. That's not what it means. Read it. It says, Congress shall not have one official religion, right? So ask yourself, is the clause being interpreted narrowly and expansively? What is the justification for the interpretation? And know one or two arguments from this slide. Okay, look for one or two arguments on each side of the cases. If you do that, you will have the cases down by heart, and you will be so ready for my test. All right, for the AP. All right, two real quick things. Remember, impeachment. These are just mechanical things. In an impeachment trial, the Chief Justice presides as the judge and the Senate the jury when the president is being impeached, right? And remember this concept of political questions. Are there questions where the Supreme Court is going to say, we are going to stay out? We are going to stay out either because the Constitution envisions this is going to be a fight between the president and the Congress. That's when it is a federal, a checks and balances issue. Or did the Constitution leave these powers to the states? Now, Baker versus Carr involved the 14th Amendment equal protection clause where it was being applied in a context where it wasn't race. Remember, suspect classes? If there's a racial classification, there's strict scrutiny. The Supreme Court said, oh, we're going to apply the equal protection clause when it's not about black versus white people, when it's not even about race, it's about voting. How did they interpret the equal protection clause? Expansively? The argument against them doing that was it was a political question. The Constitution left states to run their own state elections how they saw fit. All right? Back to the president and Congress. If the president is impeached, can he go to the Supreme Court and say, and file a lawsuit against the House of Representatives and say, hey, Supreme Court, the House of Representatives is impeaching me for getting a speeding ticket, and a speeding ticket is not a high crime and misdemeanor. This has never happened, but scholars think the Supreme Court is going to rule this way. The Supreme Court is going to say, the issue of what is a high crime and misdemeanor is decided solely by the House of Representatives. We have no business stepping in on that. It is a political question. The Constitution envisioned that in impeachment, the House would decide what grounds, and then you could either win or lose in the Senate. And we're not going to get involved as the Supreme Court. There is an issue on the War Powers Resolution. Remember my numbers? 4860. The President's got to give notification to congressional leaders 48 hours before engaging in hostilities, and has to pull the troops out unless Congress gives him permission to keep them there within 60 days. And Congress can, by a joint resolution, order him to bring the troops home. That is a what? That is a legislative veto. And the President is going to assert, I have the right to veto that. I don't have to honor a legislative veto because legislative vetoes have been held unconstitutional in INS versus Chadha, right? So, let's say the President goes and gets into a fight, or Congress actually probably goes to the Supreme Court and says, hey, we've did this legislative veto in the War Powers Resolution. The President is not honoring it. Would the Supreme Court weigh in on that? Or would they say, oh, this issue of war powers is a fight between you, Congress, and the President. Congress, if you're pissed off enough about what the President did, you can always do what? You can always impeach him. All right. Big, huge lesson. We've covered a lot, right? You guys are awesome. I love you.